Good morning, Ms. McKenna.
Good morning, Justice Marshall. If it please the Court, Gail McKenna, Assistant District Attorney for the Commonwealth. This is the Commonwealth's appeal from the judge's allowance of a motion for new trial in this first-degree murder case. In summary, the Court made significant legal errors in allowing this motion. On the record of this case, the record evidence showed, contrary to the judge's ruling, that there was evidence of motive in the case. He therefore erred in giving a curative instruction to the jury, saying to the jury that there was no evidence that there was any relationship between the assailants in this case and the victim.
Excuse me,
Sure.
just for clarification, you say that the motive was that the same person who shot the cousin 3 months before was the one who shot the victim in this case, and so that the motive was revenge.
That's correct, Your Honor.
And that's what was argued.
That's correct. And that's what had come into evidence. What came into evidence was that Santos, one of the two defendants, made statements to police that the same black man that had shot Stephen Auguste, who was one of the co-defendants' cousins, had shot at them. And then evidence came in about the relationship between Herbie Caillot and Stephen Auguste, that being that he was the cousin. That evidence was in at trial. It was fair game for the prosecutor to argue motive. He candidly said to the court before closing arguments that he intended to argue it. Defense counsel both stood silent. He argued the motive evidence, which the judge had said that it was scant. He went ahead and argued it at the end of trial. Defense counsel stood up, asked for mistrials, claimed that there was no evidence of motive, and specifically said that the prosecutor had erred because he knew of another statement that had been made by Santos, specifically a statement that was made after Santos had been Mirandized twice, had consulted with an attorney, and it was a double hearsay statement. It was Santos's out-of-court statement, which he attributed to his unnamed girlfriend. And he said that his girlfriend had been somewhere and had overheard another individual, Buddha Coward, say that he was the person who had killed Stephen Auguste. And the judge found error in that not being disclosed to the jury, and he attributed that error to the Commonwealth.
Well, did he find that it was error that that wasn't disclosed to the jury, or that it was error for the prosecutor to argue something inconsistent with that?
Well, first and foremost, he found that there was no evidence of motive, which is an error. Second, he found that this should have been disclosed to the jury.
Well, he found that it should have been disclosed to the jury?
He did. He said in the absence of that being disclosed to the jury that the prosecutor shouldn't have argued what he did. Now, the problem with that is that, first of all, this judge thought for some reason that any evidence of motive was dangerous and that it shouldn't have been put in front of the jury at all. So the defendants had already reaped a substantial benefit because at every point in this prosecution, the judge had shut down the prosecutor whenever he tried to put in any evidence of motive. The second part
So the prosecutor had been precluded from putting evidence of motive in? What evidence did the prosecutor offer on motive that was rejected?
There was no offer of proof. However, every time the prosecutor stood up and did whatever he did as far as motive, there were objections which were sustained. So really, we do have the barest evidence of motive here, and it's because objections were sustained. And what the judge said on the record was...
So you had other evidence of motive that you didn't get into evidence?
Presumably.
Presumably? Well, why don't you know? I mean, presumably the prosecutor had a basis to ask the questions.
Well, he did, and I'm basing my argument here on the record evidence of what came in, the fact that there were objections, the fact that the prosecutor was stopped in his examination every time he went anywhere near motive, and the judge said to him, evidence of motive is dangerous. I don't want
But you don't know what that
there.
evidence was?
I don't.
Okay.
I don't, candidly.
But was it made the subject of a motion in limine?
Not that I'm aware of.
But didn't the judge say, at a minimum, he said, well, there's no evidence of motive. I'm reading from the transcript, volume 9, page 14.
Right.
Defense counsel, well, there's no evidence of motive. The court, well, there's a reference. It's faint at best.
Right.
But doesn't faint at best suggest that at least there was enough there?
Absolutely. And then the prosecutor, as I lay out in my brief, went on to say, yes, I'm going to argue about motive. And defense counsel stands silent. The judge doesn't say, don't touch that. And then also at the end, initially, the judge agreed that there was some evidence of motive. But there was a lot of argument. At the end, the judge agreed that there wasn't, and he gave this curative instruction, which was more than the defendants were entitled to. And then we get to the Buddha-Coward statement, and the Buddha-Coward statement, first of all, would have been more...
Well, can I interrupt? Was the judge saying that no evidence of motive had been offered?
He found that there was no evidence of motive at trial.
Well, there wasn't any evidence of motive at trial.
Oh, yes, there was. There absolutely was, Your Honor. There was the evidence that the same black man that had shot Stephen Auguste shot at them, and there was evidence that...
Is that motive?
Yes, Your Honor. Okay. Yes. They were shot...
Revenge, I take it, is
yes.
The
right.
idea. Is that the implication is that the person who shot at the defendants, who the defendants claimed shot at them, or Santos claimed shot at them, had in fact killed the co-defendant's cousin 3 months before.
Right. And even in his decision, when the judge is talking about motive, he talks about the fact that there's an obvious connection between these two parties because there are two shootings this night. There's the first shooting where the defendants, and we're linked here by a car and cartridges from guns. There's the first shooting of the house where Terrell Murphy and the victim, Carlo Clermy's family lives, and then there's the shooting about a half a mile away in the car where Carlo Clermy is eventually killed. So the judge even finds in his decision that there's an inference that there's some connection between these people, and yet he still finds that there's no motive, even when we put in the evidence here of this connection that it's the same black man that killed Stephen Auguste shot at us.
Ms. McKenna, could I ask you, the defendant takes a position that not only is there insufficient evidence for the prosecutor to have made the closing, but that, the prosecutor had constantly evidence of that the victim had killed, is it Caillot's cousin? I mean, it's hard to... Caillot's cousin, and that knew that Santos had named another individual as Auguste's killer?
Well, Santos hadn't. What Santos had said is that his girlfriend was at a party and overheard Buddha-Coward say that he killed the person. I mean, we have this double hearsay statement that's not admissible on any ground and isn't reliable because Santos says it only after he's consulted with counsel, has been Mirandized twice, has made a number of different statements. There's no reliability behind this statement. The other problem here is the judge is holding the prosecutor to the statement as though it's true, but it's more motive evidence, and the judge has said motive is dangerous, I'm not going to let motive in, and yet here's this other motive evidence that he's not going to let the prosecutor put in.
Certainly if the evidence had come in that Santos said that some fellow named Buddha had actually shot this cousin, and Buddha's got nothing to do with this case, if that had come in, that wouldn't be evidence of motive, quite the contrary.
No, it
really undercuts motive.
It's so what?
I understand.
So what if you think it's Buddha-Coward? So what if you think it's Terrell Murphy? So what if it's... Whoever shot at the car, you believe that was the person that shot Stephen Auguste. That's the whole point. It's not whether it was Buddha-Coward or anyone else on this.
No, I understand that. I understand.
Right.
Ms. McKenna.
But, of course, they denied that they shot anybody. I mean, the defense denied that they shot anybody.
They said they were the victims, just like Carlo Clermy and Terrell Murphy.
Right.
And that was what their defense was that they too were the victims.
That they were the victims of attempted carjacking. Someone shot through their windows just as the car that the deceased was in, his windows had shot out as well.
Exactly. But essentially, here I have a murder conviction that's been reversed based on inadmissible hearsay. Based on there's motive here in the case. The judge found that there is no motive evidence, even though there is. It's record evidence. This isn't a discretionary call. This is a legal conclusion based on the record of the case. And I have a hearsay statement that's not admissible by the Commonwealth or by the defendants, and my case has been reversed based on these two combined errors.
May I just ask you again, I haven't had a chance to look at the transcript, but again, I'm looking at the defendant's brief. You've several times, I think, said there was no objection. The prosecutor said, I'm going to argue motive, and then proceeded to argue motive.
That's correct.
But at least in the defendant's brief, he claims that there was an objection.
At the end of the argument. Before argument, the prosecutor candidly stated to everyone, I'm going to argue motive.
Okay.
He argued his motive, and at the end of the argument, both counsels stood up, hit the roof. They wanted mistrials, there's objections. Judge gives a curative instruction. The curative instruction is very pointed. It says as far as the motive argument is concerned, there's no evidence of any relationship here between the parties. And this was particularly potent because Santos's counsel had argued that the Commonwealth didn't prove that there was any relationship here between the parties. And I think the reference for that is page 90 of transcript 9. But it was very potent because it not only undercut the Commonwealth's case, but it bolstered the defendant's argument. It was a very powerful argument, a very powerful curative instruction. And after that, Caillot's counsel was satisfied. Santos's counsel got up and said, thank you, but I don't think that's good enough. And that's not the type of pointed objection that's helpful to the trial court in saying, can you use this language, can you do this, this would be more helpful. It was really kind of a half-hearted type of objection.
Ms. McKenna, remind me, when was the conviction?
The conviction was
1992?
1998.
I think.
Oh, no. I'm sorry, the conviction was when?
In 2000.
I thought it was 1998.
I think
may
you're
be
correct.
wrong. I thought the trial
When was the homicide?
Correct. 96.
Okay.
November of 96.
And was, do we have one judge here?
Judge Sikora.
So who is both the trial judge and the
Yes.
and the motion for new
Yes,
trial?
and
Okay.
part of my argument here is that we're dealing with errors of law. We're not
Right,
dealing
no, I
with the type
understand.
of errors that he would normally get the type of discretion that the court would award to the judge.
Okay.
Now, I'm sorry.
Okay, can we move to the guns?
Yes.
Please explain the guns to me. I've read these briefs. I am very confused about what was produced when, to whom, and how.
Well, I think the best thing to do is to focus right in on the judge's decision and cut right to the chase and past, the Commonwealth objected to this motion and so on. At the end of the day, what happened here is that it turned out that the guns were found before trial. The Commonwealth did not know that the guns were matched to this murder until after the trial. That's what Judge Sikora found. They were tested. It turns out that gun 2 was matched to the projectiles that were in that killed Carlo Claremy. What the judge found here is that what the defendants came up with wasn't good enough to meet the Grace standard, but he combined this supposed error with the motive error.
No, I understand that. We need to go back. What was disclosed pre-trial as to, first of all, let's go back to this. I take it that the cartridges at the first shooting, the house shooting,
Right.
matched the cartridges at the murder scene, the second shooting.
Yes.
So there were 2 guns, and there were cartridges from both guns at each place, right?
There were 3 guns.
I know, but there were 2 guns
Yes.
that were involved in both shootings.
Right, guns
And then
2
there
and
was a
gun
3rd gun that one of the
Terrell Murphy's gun.
victims, the driver of that car, fired. So,
Correct.
right. So they were matched. So there was
Right.
established a link, and that was all disclosed to the defendant, of course.
Absolutely.
All right. Gun 2, which is the gun that apparently now killed Claremy, the victim in this case.
Right.
That gun had been used in a subsequent murder, correct? Or a subsequent shooting?
2 was used, yes, in a subsequent non-fatal shooting of
Okay.
Jerry Deslinas.
And that was known at the time of trial.
And that came out at trial.
Okay, so the Commonwealth disclosed the fact that cartridges in connection with this subsequent shooting, some year and a half
Correct.
later, matched the cartridges found at the murder scene.
Correct.
Right, so that was disclosed, and that came out at trial.
Right.
But at the time, I take it the Commonwealth did not know that gun 2 actually had been recovered
Correct.
in connection with some other arrest.
Correct.
All right, so you didn't disclose that because you say you didn't know it.
As the judge found.
Now, gun 3,
Right.
Gun 3 was also found before the trial,
Right,
and you didn't know that that gun had been found either.
correct.
And Gun 3 was recovered in connection with another murder investigation.
Incorrect.
Okay, it was not recovered in connection with another murder investigation.
It wasn't, and that's where the judge made his other factual error.
Mm-hmm.
There's no evidence at all in the record that connects that gun to the Donald Averett murder, which is actually the murder of Alex Caillot.
Oh, okay, I'm just really confused then. But Everett was charged with possessing the gun?
Right,
Okay, and it was seized in a trash barrel next to which he was standing?
correct.
All right, so you're saying it had no involvement with Everett?
Nope.
All right.
No, as set out in my brief, in fact, the murder that Donald Averett was indicted for, he was acquitted of.
Mm-hmm.
And there was a motion filed in that case to exclude the gun that was found near him in the trash because it wasn't connected to that murder.
And that motion was allowed?
Presumably. I mean,
You don't know whether the motion was allowed?
the problem is he was acquitted, so there's
Did
no
the government use
transcript.
the weapon against him at the trial?
No.
It didn't?
No.
So it was either allowed or it was not, it was voluntarily withdrawn from
The government
evidence?
wanted to present the weapon to show that he had access to a similar weapon,
Sure.
which is something that that is allowed.
And so the government did use the gun at the Everett trial?
I don't know if it actually, I know that that's what the government wanted to do. I don't know what actually happened. There's no transcript because he was acquitted. And that's the other issue here, is that because Donald Averett was acquitted, he wasn't found guilty of that murder. The other issue is that his co-defendant was found guilty. His co-defendant confessed and put a .38 in his hand, not a 9mm, and this is a 9mm.
But there you recovered the bullet from the murder, did you not?
From
The murder that Averett and this co-defendant supposedly committed. That bullet
Alex
was recovered.
Caillot murder.
And what did that match? A 9mm or a .38?
I don't know.
Okay.
I don't know. But at the time of this particular murder, Donald Averett and LaJuan Melton was 16 years old.
So what?
And they were shooting at specific people. There's no connection between them and this murder.
Except the gun was found either in the possession of Averett or right next to him, and he was charged with possessing the gun 2 years later.
Right, but there was no tie between that gun and the murder of Alex Caillot. There's nothing in the record that connects that gun to that murder. In fact,
But there is something in the
just
record that
opposite.
But there is something that connects that gun to Mr. Averett.
Well, that
Or
comes-
why would you have charged him with it?
But then, well, I mean, the theory of the defendants here is that there's some sort of signature crime going on, and that black males in the city of Brockton connected to this gun between the ages of 16 and 37, 5'2" in height to 5'11" in height, in weight of 105 to 175 pounds, are somehow connected in this huge conspiracy of a signature crime.
Well, that may be your
And-
view of it, but that's not what the judge viewed. I mean, the fact of the matter, these guns were not recovered from the defendants, who were arrested very shortly, within minutes of this shooting, as I remember, at the
That's
hospital.
correct. Well,
They were not recovered.
Within about 20 minutes,
Okay.
they were at the hospital.
All right.
That's
So
correct.
guns were not recovered, and I
They
know
were in
defense counsel used that at trial. They were subsequently involved in other crimes when these folks were in jail.
Right.
And so the question is whether that is evidence that perhaps they weren't the ones who did this shooting.
Right, and it came in at trial that these guns were still in circulation after the murder. That the jury knew that. But as far as saying that Donald Averett and the murder of Alex Caillot is somehow connected to this, the
Well,
defendants haven't met their
the jurors didn't know anything about gun 3, right? They didn't know that.
They knew it was still in circulation.
Okay, but they didn't.
to tell them that that someone's 16 at the time of the murder and you haven't been able to connect this gun up at all to a murder of Alex Caillot, there's no evidence here, and it's the defendant's burden to come forward with that evidence.
Well, it's
They
actually
failed
the
to do
government's
that.
burden to disclose this prior to trial.
Well, and the judge found that the Commonwealth didn't know.
Didn't know.
Right, and we didn't. What we did is we disclosed the worksheets as they existed. They're a snapshot. They're in continuous updates. The problem was that as updates were made, they weren't dated. And the judge found in our favor on that matter. The other issue here is that as far as the gun is concerned, the judge found that standing alone, it didn't meet the Grace standard.
Well, he may have found that,
combined
but
it-
you've asked us to reconsider and look very carefully at the judge's findings.
I've asked you to reverse what he has found here, and I've said that he's committed 2 errors of law here. Now, he found that this didn't meet the Grace decision. And based on what was admitted at trial, which was the fact that the guns were still in circulation, that gun 2 had been used in another crime, that the guns had been used in prior crimes, the evidence was there before the jury. It wasn't a significant matter. It was 1 page of the transcript in this 2-week-long trial. It simply wasn't as big a thing as has been made out to be.
Well, I mean, if they had known, if they don't...
I'm sorry, Your Honor. Now we know that the fatal bullet, in fact, came from gun 2, so our case at this point is even stronger.
Why is that?
Because we know that it's the murder weapon.
Gun 2?
Right. And,
which was found in the possession of whom?
well, it was found...
Not one of these defendants.
No, it was found in the possession of a 37-year-old who said he was holding
Right.
it for someone else.
So I don't know how that
Many
strengthens your
years
case,
later.
frankly.
Ms. McKenna, I know the time is running. Mr. Harwood, don't worry. You'll have plenty of time to answer it. There's one, if Justice Corey's finished,
Yes,
there's one question, which is the Crawford issue, which is not one of the reasons relied upon by the motion judge. I know that. But you,
Correct.
I think not inappropriately, for some purposes, say, wait until this comes up on direct appeal.
Certainly.
But wouldn't it make sense for us to look at it, I mean, just in terms of economy here, namely, if there is a problem, and I raise that because as I read your reply brief, which is very helpful, you don't address the substance of it.
Well, the problem is, Your Honor, I'm here under an order from the court saying that I'm to brief only my appeal.
No, I understand that.
Right.
And so you appropriately raised the problem for me, but what I'm asking is, would it make sense for us to look at it, in which case I could let you address it substantively? Because it seems to me that if there is a real Crawford problem, to sort of close our eyes to it and to say, well, we'll do something on the motion for new trial. Let's assume that we agree with the Commonwealth for the moment. Then we get a direct appeal. Then we decide there's merit to the Crawford issue, and then it goes back for a new trial. That doesn't seem to me to make a great deal of sense. I can't tell you which way the court will rule on the motion for the new trial, but I'm trying to see whether, from the Commonwealth's point of view, as I understand the defendant's brief, they've laid out the substance of it, and I understand that you very carefully complied with the court's order. And I'm just asking, and you don't have to make a decision now, but why don't you think about it and then send a letter saying, no, I think this should wait until the direct appeal, or I'd like to have an opportunity to address it substantively now.
I can answer right now.
Okay.
I'm happy to do whatever the court would like me to do on that matter. If you want me to do further briefing, that's fine. I think that, though, that might be a difficult exercise, because if the court does find in my favor, what will happen then is that they will get their full 33E appeal.
With you, okay.
I'm not sure what to say. So I would leave it to the court's discretion, whatever order the court wants me to follow.
Why don't we assume that you do nothing at the moment, and if, the quorum decides otherwise, then we will let the parties know.
Okay.
So we'll just rest on your reply brief saying, hold these issues until we get a direct appeal. I think you addressed, well, in any case, that's fine. Thank you, Ms. McKenna.
Thank you all for your kind attention. I would ask that the judge's ruling in this be overturned.
Thank you. Mr. Harwood.
Good morning, Your Honors. I'm going to be addressing primarily the closing argument of the prosecutor, although it does dovetail into the guns issue as well. The standard of review is whether or not this judge, who heard all of the testimony, who heard all of the evidence on the motion for new trial, which was lengthy, and who considered all of the factors brought to his attention, abused his discretion in granting the motion for new trial. And in this case, what should be clear is this. There was no evidence that Carlo Claremy had in any way murdered Stevie August, who was Herbie Caillot's cousin. There was no evidence.
But what matter is that? It only matters what the defendants may have believed.
No, not really, Judge, because what the prosecutor argued was that the motive for this killing was that there was a shooting of Clairemy's residence at 46 Winthrop Street. This was not an argument that it was just somebody made a mistake at an intersection and therefore began shooting through their car windows. This was an argument by Mr. Ashe that...
He's the prosecutor?
He's the prosecutor, the trial prosecutor, that first they went to 46 Winthrop Street and shot at the house of Mr. Clairemy and Mr. Murphy. And then when they didn't find or achieve any result there, that the assailants then, in effect, ambushed Mr. Clairemy and Mr. Murphy's car at Warren and Nielsen Street. So this was not an argument made by the Commonwealth, and Judge Sikora says this. They did not argue that this was a shooting at an intersection where somebody mistakenly shot the wrong person, thinking it was Buddha Coward. The prosecutor argued that this was a premeditated murder involving two locations, and he specifically argued that in the absence of any evidence, and none has been posited to you today, that Clairemy and or Murphy murdered Herbie Caillot's cousin. And the prosecutor has admitted here today, and they don't dispute it in their brief, that any type of evidence that would have come in like that was excluded. And there was no evidence in this trial that that there was any connection made between Clairemy and Stevie August. And so for the prosecutor to get up and argue that there was a connection between Clairemy and Stevie August was not only not supported by the evidence, but it was contrary to the statement which Santos made, which was then bits and pieced together.
What was the statement that Santos made?
The statement that Santos made was, and Judge Cordy touches upon it, he never said that he shot out of the car. He says that somebody came up to his car to carjack him, and that the person shot bullets into his car. He never says that they exchanged any gunfire, and he says that it was the same N who had shot Herbie Caillot's cousin.
That would be Stephen.
That would be Stephen. But he never said in any way, he then tells the police that the person he's talking about is Buddha Coward.
But that's the next day, different police officers.
No, it's the same. It's later that night when the police are talking to him further at Attorney Abelson's office. And to say that the Buddha Coward part is hearsay, but the other part isn't, is like saying, here's a hearsay statement. Let's take the part that we want to use, ignore the part where he says, we never fired at anybody, and ignore the part where he says, and it was Buddha Coward. I mean, to me, and I think to Judge Sikora, you can't, bits and pieces a statement.
May I just read a portion of the testimony, because it seems to be inconsistent with what you said. This is the testimony of Detective McLaurin. I asked him who Stephen was, and what response did he make? He told me that Stephen was Stephen August, who had been killed 3 months prior. All right? He said he was killed 3 months ago. What else did he say? He told me it was Herbie's first cousin. All right. Did he say who killed Stephen August 3 months ago? Yes. And what did he say? Again, he said it was the same black guy that had shot into the car. Now, isn't that a connection?
No, because that could be Buddha Coward. That's not a statement. What the prosecutor never did, and this is what Judge Sikora hits upon, they never introduced evidence that the person who killed Stephen August was Carlo Clairemy. They never introduced any evidence that there was a connection between Clairemy and or Murphy and the Stephen August killing.
Well, let me interrupt you once more, because at another point, the district attorney said, you need a motive, ladies and gentlemen. You got one right there. Revenge, the oldest motive known to mankind. Think about it when you deliberate, and doesn't that complete the circle? Doesn't that tell us that the guys in the green car that shot up 46 Winthrop Street are the same fellows here? This is not a coincidence.
But isn't
that stating what the prosecution's theory of the motive is?
They're arguing, if you look at that same comment, He says they had knowledge of this. He has knowledge of it. He told it to the police. And does that give them a motive to shoot Terrell Murphy and Carlo Claremy? In other words, he's saying that it's Claremy who shot Stevie August and killed him 3 months ago. And I would say, where there's no evidence to support that and a contrary indication from the defendant's statement that it's Buddha Coward, it's even more harmful because then it gives the jury a reason why.
When does the defendant say that it was Buddha who did the shooting?
He says it at Barry Abelson's office. Later that, like within hours of the first statement, he's interrogated further, and he indicates it's Buddha Coward.
Santos stated that Buddha Coward shot Stephen August. He stated that his girlfriend, whose name he would not divulge, heard Buddha bragging about it. Isn't that a totem pole hearsay?
It's no more hearsay than the first part where he's indicating that, Stephen August is killed by somebody. I mean, to say this part is hearsay, but this part isn't, it doesn't hold water. The main problem that Judge Sikora was seeing is there was no connection between Stevie August's murder and Carlo Claremy. So to take bits and pieces of statement and hoist it up as a motive, I would say it's even more pernicious because then it's a link to 46 Winthrop. This was not, again, a transferred intent argument made by Mr. Ashe. He did not say or argue that they thought they were shooting at Buddha Coward at an intersection. He never made that type of argument. He made the argument that they were shooting at Claremy and Murphy because of what happened and because of Claremy's involvement in the Stevie August murder. And that's why they went to Claremy's home and then the intersection, none of which was supported by the evidence. The Commonwealth never introduced any evidence linking the August murder to Carlo Claremy, nothing. And so the judge said and warned them, there was a warning when the prosecutor would pursue this questioning, don't go near there. You don't have evidence. You're not making any proffer. And that's another question asked by the panel. Did the prosecutor this morning indicate what evidence there was that Stevie August was murdered by either Carlo Claremy or Terrell Murphy, whom they never charged with it? Did the prosecutor go to sidebar and say, this is the evidence, Judge, that we have of a connection between Stevie August's murder and Carlo Claremy? He never made any proffer of evidence like that, presumably on this record, because he had none. And yet he wanted to argue motive because there was no identification of Santos and Caillot as the assailants by Terrell Murphy. So he tried to buck up a case by saying there must have been a motive. That's why they went to 46 Winthrop, and that's why they had the shooting at the intersection, because this guy killed Herbie Caillot's cousin, even though there was zero evidence of that and no proffer made by the prosecutor of what evidence they had. And that's why when you get before the court here today to say at Buddha Coward was something mentioned by the judge in the motion to suppress. There were specific findings when Santos filed the motion to suppress the statement and it was denied. That reference to Buddha Coward is something that Judge Sikora makes note of in his opinion. This was not something that came out of left field. The prosecutor knew or should have known that Santos's statement included the reference to Buddha Coward. And
so what you're saying is that based on the evidence that came in, and it's very brief, it's not a heck of a lot, that it was not inferable that Santos thought that one of the victims here was the one who shot Herbie's cousin, nephew, I keep getting this mixed up, August. It was not inferable that Santos thought that one of the victims was the person who shot August. It's not a reasonable inference.
I would argue it is not, that the prosecutor argued that the motive for the crime was that Claremy had killed Stephen August. There is zero evidence.
Not that Santos thought that Claremy had
and
killed.
that there was no argument advanced by the prosecutor along a transferred intent line of what your judge is positing. He did not argue that he thought he was shooting Coward, but instead he shot this this other person. He never argued that because he argued, no, first he went to 46 to shoot Claremy, then he went to the intersection.
Okay.
This is a contrivance that's made on appeal to uphold a bad argument.
But wait a minute. Doesn't the district attorney lay it out when he says, this fella, he says, and isn't it convenient or coincidental or maybe just a random circumstance that the guy this fellow says is responsible for shooting in the car is responsible for his first cousin's murder 3 months before? They had knowledge of this. He has knowledge of it. He told it to the police. Doesn't that at least explain that the defendant thought that the person was responsible for killing his cousin?
That he was mistaken in his belief.
Could have been mistaken.
But that's not the
evidence.
Not the argument. There's no evidence that Carlo Claremy had anything to do with the murder, and there's no evidence that Santos, in his vehicle from this statement, shot out at anybody.
But what about his statement to the police where he said he thought that it was the same guy that shot August? Is it not inferable that Santos meant by that statement Claremy?
No.
And tell me why.
Well, because, A, there was no admissible evidence at the trial linking the two.
Yeah.
And that's the problem with the prosecutor arguing something he knew was contradicted by the statement. That's the other problem that the trial judge had with this. And also, in this case, you have the balance of the statement, which is not suppressed by the judge, in which he indicates it's Buddha Coward. So the problem really here is, rather than try to lump it all together generally, you have to focus on what the judge did, and it's a little bit of a brain teaser, but the bottom line is the judge was disturbed because Stevie August's killing was never connected to Herbie Caillot. The Commonwealth, had they had evidence, could have done that, but they didn't. And they didn't do it in admissible form.
So there's no extrinsic evidence to explain what Santos said in his statement to police, that it was the same guy that killed August?
There's no extrinsic evidence, and Santos's own statement indicates it was not Claremy.
Not in his own statement, but there's no extrinsic evidence to explain what Santos meant when he said it was the same guy that killed August.
That's true, but you have Santos's statement saying it was Buddha Coward. You have a negatory from the statement.
That's not my question.
Right. I don't disagree at all with what Your Honor just said.
Okay.
But in this case, the motive evidence wasn't there. There was certainly no evidence of, and Judge Sikora, who made a very thoughtful decision, said there's no evidence of specific motive here. He applied the test articulated by Judge Cordy in Arroyo and looked at the 4 prongs. He said there was an objection. To argue otherwise borders on disingenuous. Each of these defendants not only moved for mistrial and dismissal at the argument, but when the curative instruction was given, they said that's inadequate. He found that it went to the heart of the matter because the motive was what was used to explain not just the intersection shooting, but what was at 46 Winthrop. He went on to say that he gave an instruction that the two didn't know each other, but he said that's not really enough. What we say he needed to do was say there is no evidence that Stephen August was killed by Claremy. There is no motive evidence, so disregard that testimony, disregard that closing argument on that point. So Judge Sikora, having heard all the evidence and having considered what the jury heard and having witnessed the impact on the jury, said, I find that it was not forceful enough. And on prejudice, he said, basically, I think it could have affected the jury's decision. I think that given the repeated, and he called the vehemence of the prosecutor's statements, and the repetition of the motive, that it could possibly have affected the jury's decision. And that's not an abuse of discretion for a learned judge who's been on the bench, who knows the evidence, to wrestle with this and then to come to a conscientious decision that a new trial is warranted. And certainly, after the fact, in the summation, the prosecutor also argued no guns were ever recovered. This is my segue into Mr. Barter's argument. But certainly,
I thought you were going to segue and then sit down, Mr. Howard.
When we then find out after the fact that the two alleged murder weapons were in fact recovered, and when in fact at one point Arnold is saying to Trooper Wakefield, well, shouldn't we really test this gun? And she says, no. That, in my view, speaks volumes. When in this case, we had to fight for every piece of discovery we got in this case. If Judge Sikora had not allowed discovery motions, which is not a given, very difficult to get discovery.
Post-trial discovery motions.
We were told, even in post-trial, no, the guns were never recovered. No, the guns were never recovered. Then one day, in Dedham Superior Court, lo and behold, Arnold gives us these reports, and we find out there are matches not to one, but to two guns. And the same prosecutor is arguing guns were never recovered. And, the judge says it was unintentional, for Brady purposes, whether it's unintentional or intentional, putative knowledge is imputed. Mr. Barter will talk about that. But just given that issue, in addition to the bad summation, there really is no abuse of discretion here for a conscientious judge who heard the trial, who heard all of the evidence, who saw the evidentiary hearings, who considered everything. This was not an abuse of discretion. This was a proper grant of a new trial. Thank you.
Thank you, Mr. Howard. Mr. Barter?
Good morning. Just as Mr. Harwood has briefly touched on the matters that I'm hoping to cover, I want to touch very briefly on the closing argument, just to point out that in the course of the trial, Judge Sikora cautioned the Commonwealth about pursuing this issue, and I believe the motivation of this was Judge Sikora recognized that Herbie Caillot had a cousin who was killed a few months earlier. The fact that someone was killed a few months earlier, as Judge Sikora suggested, the jury shouldn't be told that there's some sort of guerrilla warfare going on, whereby we can assume for every action there's an equal and opposite reaction. That's just not right. We have to have evidence that there was some involvement between these parties before we start taking the unfortunate death of this person's cousin and saying, there's your motive.
Well, there was a little more than just the existence of the fact that his cousin had been murdered. Wasn't there testimony from the police that they had interviewed Herbie Caillot as they looked into the cousin's murder?
Yes, there was. And there was testimony from, I believe it was Officer McLaren, to that effect. And on that point, Justice Spina asked, well, was there a motion in limine with regard to these issues? And the answer is yes. It's at page 72 of the record appendix. A motion in limine was filed by counsel saying, look, let's not let any evidence come in about the fact that Stevie August was killed a few months earlier. That's just not fair. And so this was anticipated. Every effort was made to keep it out. Every effort was recognized by defense counsel that this is getting into dangerous territory to be attributing a motive simply because someone had a family member that was a victim of a violent crime. And I think that is part of the offensive part of this closing argument, to be essentially capitalizing on the fact that Herbie's cousin was a victim of a violent crime. But to get on to the guns, I think there are some very important issues with regard to the guns.
So I take it there was an affirmative ruling on that motion in limine.
There was a specific ruling, a marginal notation to the effect of, let's see how the testimony develops at trial and we'll address it then.
And it was addressed at trial.
And at trial, when the issue would come up, counsel would go to sidebar, and over and over again, Justice Sikora would say, these questions you're asking, Mr. Ashe, just carry too much freight. You're asking all these questions to try to get in front of the jury the notion that there's been a killing here. And I just don't think that those questions are appropriate. And I caution you to stay away from that.
When the prosecutor handed out, I take it before his closing argument, that he was going to argue the question of motive, did he indicate that he was going to argue this Claremy death as the motive?
Well, exactly how that came up in the charge conference is kind of hazy to me. I heard my sister arguing that it came up in some detail. My recollection of it is, Your Honor, that when the prosecutor said, well, I'll be arguing motive, that defense counsel indicated, well, there should be an instruction to the effect that motive ought to be proven beyond a reasonable doubt or something to that effect. But I don't recall the prosecutor saying, I plan to argue that Stevie August was killed by Claremy or Murphy. I'm sure that wasn't the nature of the disclosure of the motive argument, because in very animated fashion, it practically jumps off the transcript pages in Volume 9. Counsel are jumping out of their skin. They're so upset, saying, this is prosecutorial misconduct. There should be a mistrial.
Why didn't they do that beforehand?
I think that, again, I haven't read the full transcript, so I'm looking at what the Commonwealth gave us in its brief, and what it seems to be is the prosecutor is saying, I'm going to ask the Commonwealth for an instruction. If the defense attorney says there's no motive in this case, I'm going to ask for an instruction that the Commonwealth is not required to prove motive. And the judge says, let me see what defense argues. If there is motive in closing argument, I read that to mean if the defense is going to argue that there's no motive here, I think you entitled to an instruction. And then the prosecutor says, I will be arguing it. There is a motive in this case, but I still would like to have the requested instruction, please. That doesn't tell me exactly what it is that the prosecutor is doing, because I think the judge is focusing on whether or not he should be required to give an instruction that the Commonwealth is not required to prove motive, if there's no motive.
I understand that, but I know, and I apologize for not being more precise about this, that defense counsel similarly said that if this motive stuff comes in, we should have an appropriate instruction.
Okay.
You want to get to the guns?
Yes, yeah, I would. In this case, Your Honor, Justice Cordy asked what was disclosed prior to trial, and what was disclosed prior to trial was put into evidence in the post-trial proceedings as exhibits number 27 and 28, which begin on page 260 of the record appendix for one set and 278 for the other. What this is it's a set of worksheets that were sent a couple of weeks before trial by the Commonwealth to defense counsel that lists certain issues with regard to the analysis that was done on the casings and the projectiles that were found in this case, and there are some other papers in there that the court will have an opportunity to see. What wasn't disclosed, but what did exist, was the fact that each of these guns was recovered prior to trial by the Brockton Police Department, in some cases, same officers involved in investigating this case, was brought to the state police lab over in Sudbury, was examined by Trooper Arnold, the state police ballistics officer, who is the clearinghouse for such information. He examined these guns, he test-fired these guns, and he returned them to the Brockton Police Department. In spite of that...
when you say, was the result of the test that they were operable guns, or was the result of the test that the bullet matched the bullet that killed Claremy?
In each of those cases, the marching orders of Trooper Arnold, if you will, were, we've charged these two separate men with possession of a firearm. These are the firearms we found in their possession. We need to have certificates showing that they're operable guns, which Trooper Arnold provided in order to assist in the prosecution of the possession of a firearm cases against Watkins, a 5'9", 130-pound black man, and Averett, a 5'10", 160, 170-pound black man, who were found in possession of the weapons that the Commonwealth says were used in this shooting. The evidence at trial was that, with regard to the 46 Winthrop Street, a thin black man, maybe close to 6 feet tall, was seen getting into a car. The evidence with respect to Claremie, the intersection shooting, was a shadowy figure came out, shot, and left. So we have no evidence of any great detail about who the assailants were in the Claremie shooting. But the evidence we do have brings these two individuals who were found and charged with by the Commonwealth. They had to put an officer in front of a clerk magistrate to say, I'm swearing out a complaint. Or with regard to anything that was indicted, I have a good faith belief that these guns were owned by these people. And in the case of Watkins, he was convicted of the possession of that weapon. And in the case of Averett, his prosecution fell apart because of bad Miranda warnings that were given to him. Half the significant evidence in the case against him, the Cologne case, was suppressed because the evidence was improperly solicited or elicited.
But what you did know at trial was that the guns indeed had not been recovered from the defendants, your clients.
Yes.
And that was argued, I take it, as evidence that they didn't do the shooting because the guns were not recovered. So the jury was aware that the guns were still out there if, in fact, these defendants had used them.
The jury was certainly aware that the guns were not.
Your position is the jury did not know that the guns had in fact been recovered in the hands of other persons and that those guns were the murder weapon.
That's right. The jury didn't know that. The one thing, and Justice Cordy touched on this, and it's mentioned in Justice Sikора's decision, the one thing that was known was that a single shell, a single 9mm shell, matching up to what we're calling gun 2, was found close to the place that someone named Dessalines was shot. The Commonwealth fought tooth and nail to keep that out at trial, but Justice Sikora said, no, this is fair evidence. This jury should not go in to deliberate without knowing that shell casing was found near the Dessalines shooting.
And the Dessalines shooting occurred about a year and a half or so after this murder?
It occurred in May, yes, I'd say approximately a year and a half after this shooting. Okay. But what the jury didn't know, but what was in the government's files, and what Justice Sikora finds they had putative knowledge of, was that, and I know the Commonwealth doesn't want to spend a lot of time on this, but we fought tooth and nail with motion after motion after motion, small bit after small bit, with the Commonwealth, no fishing expedition, stop the fishing expedition, until finally we found
fish. Finally you caught fish.
Finally we caught, several fish. We found that Dessalines was shot in the head and in the back while traveling in a Honda in Brockton by the same gun that shot Claremie, who was traveling in a Honda in Brockton, same gun, hit in the head, hit in the shoulder. In one case it was fatal, the other case it wasn't. The jury knew, there was one stray shell found, we don't know, much about it, and the defense wasn't told much about it. And as I say, we fought for 3 or 4 years to finally get these documents. These were the last things we got in this case, what was the evidence of the Dessalines shooting. And so now what Justice Sikora sees is he actually sees the creases going across Mr. Dessalines' head where he was shot. He sees there was a fusillade of gun shells here. It wasn't just one Israeli shell with a discharge marking that's similar, which is the only thing that was disclosed to the Commonwealth, to the defense by the Commonwealth, and that's at page 262 of the appendix. It's a lot more than that. He was shot in the same kind of car, in the head, in Brockton, with a fusillade, 8 shells found on the street. Beyond that...
From the murder weapon?
From the murder weapon.
All 8 shells were from the murder weapon?
Pardon me?
All of...
Yes.
This
Yeah.
is the Dessalines shooting.
The Dessalines shooting involved a single
Now, did you,
weapon.
were you given information, you said you got information prior to trial that one shell in this Dessalines case had been found, and that shell matched a shell fired at the murder scene, right?
That's right. That was disclosed on September 15th, 1998, which was about 3 weeks prior to trial.
And were you also given information about the Dessalines incident, the fact that there
No.
were, well, you weren't?
No.
So
In
the
fact,
police reports and nothing of that sort?
No, we asked for those post-trial, and the
Okay.
Commonwealth said, don't let them have it. No, Judge, don't give it to them. Don't give them that. And it went on for months, and the judge
What's
finally
our
did.
standard of review here? What are we looking at? To see if the trial judge committed an abuse of discretion or error of law? Or are we looking at everything de novo?
It's definitely an abuse of discretion or error of law standard with regard to a motion for new trial, and deference should be accorded to the trial court. The Commonwealth suggests it's a pure legal issue, so you don't need to give any deference. That's not quite accurate. What we have here is the trial judge not only heard all the evidence at trial and saw the jury reaction, he heard the testimony of Michael Arnold twice. Michael Arnold, the first time, testified the weapons were never recovered. And then he saw the sheepish look on Michael Arnold's face when he came in and said, these are gun 2 was found. And we said, holy moly, can we see the evidence about that? Then the next day, Michael Arnold comes in and says, oh, you know what? Gun 3 was found too.
Well, when was the ballistics report concerning the matchup of gun 2 with the Claremy murder? When was that ballistics report authored?
That's a very good question, and unfortunately there's no answer to it. We put on our own ballistics expert, who was formerly the head of the Firearms Investigations Unit, who indicated best practices are to date your comments, to keep a running tally so you can tell when things happened. But Trooper Arnold testified, no, we would just kind of write it in. We'd write things in, and no, we didn't date them. We'd write in a comment, and we'd put in our initial.
Wait a minute. Don't they have to submit copies of all their reports to the colonel? Don't copies of all state police reports go to the colonel in charge of the state police?
Well, in this case, Your Honor, what we're looking at is the Special Investigations Unit, which is over at Horse Pond Road in Sudbury, where they have their own internal structure, and I'm not sure that these are what have been referred to as worksheets. And I don't know that they reach the level that they have to go to a colonel at some other level, or what the administrative process is. And Justice Sikora says, well, maybe their method of keeping records was rudimentary, or maybe they made a good faith mistake here. And I'm not going to say that the Commonwealth tried to suppress this evidence, but they had putative knowledge of this. And under Gallarelli and Lamhue-Tow, a couple of the cases where weapons weren't turned over, this court has been very aware of the importance of the instrumentalities of the crime. And in Gallarelli, where I was counsel in that case on post-conviction, and in that case, we found that a knife, there was testimony at trial, the knife was lost when the officer died. And I found a few months after trial, when I became involved, well, maybe the knife was lost, but the laboratory has the report. And this court overturned the trial judge who denied my motion for a new trial and found, look, this is having to do with the instrumentalities of the crime. And if I might mention, I was asked the standard of review. Specifically in this case, we have Brady material. And as this court recently pointed out in Laguerre, this court still follows the Aggers analysis. If there's a specific request for the information, and if the information isn't turned over, if there's some probability that this would have affected the jury, that's enough. In this case, our requests were more specific than you can imagine, and they're in the transcript. A motion was filed pre-trial saying, the Commonwealth says it has no idea where the guns are, but they might have been recovered. Could you please ask them to look? And maybe they're out there, and maybe they were used in other crimes.
When was the bullet taken from Claremy's body sent to the Firearms Identification Bureau for comparison?
Almost immediately. The one from Claremy's body?
Yeah.
It went it was examined within days
Of the murder, of the homicide.
of the death.
So it had just sat there? It just sat and it didn't get returned, saying, look, we haven't...
No, the Claremy evidence was examined at the State Police Lab.
Yeah.
And then the process that they go through is once they've examined it and done all of their work and written their reports, they give it to the officer who is an adjunct to the district attorney's office to hold on to until the time of trial.
But it wasn't compared to Gun 2 at that time?
It wasn't compared to Gun 2 at that time.
So did it go back to the Firearms Identification Bureau, the bullet? Or did it just stay with them from 1 week after the shooting?
It did not.
So I take it they had that bullet from Claremy's body at the time of the trial?
Yes.
And it's in the court. It's been there, right?
It was in the court for a period of time.
What do you mean for a period of time? It's not there as evidence? It's still not
Is it
there?
in evidence?
My understanding is in this particular case, it was in the custody of Trooper Wakefield, who it was signed over to prior to trial. It was admitted into evidence at trial.
So it's still in the clerk's office, right?
Well, as of right now, I believe it might be in the district attorney's possession. But in this particular case, these things went back to the State Police Lab at our request so that our examiner could look at them. And then we asked Mr. Arnold if he had looked at them after all of this happened, and he said that he hadn't. So there was no subsequent examination of those bullets or those projectiles after the time of trial by the Commonwealth.
So that the comparison would have had to have occurred before the trial?
No, the thing that's significant in this case is that it was the casings rather than the bullets that made the difference.
Okay.
And what they typically do and what they have is a special unsolved case file, a drawer, where they have casings from each shooting in Brockton so that they can compare them as other guns come in. So while the evidence in chief went back to the court to be introduced, the state police, based on the testimony, keeps an inventory of the casings because they find that the casings are the more reliable or more accessible form of evidence for purposes of comparison. And it was based on those comparisons of the casings that Trooper Arnold called up Trooper Wakefield, who was adjunct to the district attorney's office, called up Trooper Wakefield and said, I'd really like to look at that evidence. I think I might have a match here. And the note written on the running sheet from Trooper Arnold is, Trooper Wakefield declines. And when we asked Trooper Arnold what that meant, well, he said, well, I guess you didn't want to give it to us. So we have a case here where even when someone within the state police is saying, gee, we have something going on here, we should look into it, the reaction from the officer who's involved in the investigation of this case is, thanks, but no thanks. We see that comment. We have that in the transcript from Trooper Arnold. We know that the Commonwealth opposed this discovery at every point. We know that Judge Sikora found that this was presumptively known.
Putatively known.
That I'd suggest that based upon the Brady evidence alone, the newly discovered evidence alone, that a new trial was appropriately allowed, and in conjunction with all of the other issues, certainly so.
Thank you, Mr.
I apologize for taking so much time.
Thank you.
Thank you.